colleagues, Alejandro Ortiz, who is an attorney with the ACLU Racial Justice Program. And he's going to discuss the history and an overview of the US Supreme Court insular cases, their impact and relevance today, as well as the current and ongoing work that the ACLU is doing to fight for the rights of the peoples in the US territories. So let me begin by introducing our guest speaker, who we're very honored to have here, Alejandro Agustin Ortiz. So as I mentioned, he is a senior staff attorney with the ACLU's Racial Justice Program. In that role, he focuses on promoting economic justice for vulnerable communities, including in housing, labor and employment, and equal rights for inhabitants of US territories like Puerto Rico, Guam, and American Samoa. Previously, he was a senior field attorney with the National Labor Relations Board in the Manhattan Region 2 office, which is where I worked with him on very complex litigation against McDonald's USA for the last, well, before he left, for a couple of years. Among other cases and McDonald's, he investigated dozens of unfair labor practice cases in that role. Prior to joining the National Labor Relations Board, he clerked for Judges Christine M. Arguello and William J. Martinez of the U.S. District Court for the District of Colorado, and Magistrate Judge Justo Arenas of the U.S. District Court for the District of Puerto Rico. He obtained his Juris Doctor from the University of Colorado Law School and his Bachelor of Arts from Virginia Tech University. So without any further ado, I now present to you Alejandro Ortiz.
Hey, Nicole, thanks for the introduction. It's great to be invited here to speak with you all about this important set of often ignored Supreme Court cases and how they're still relevant today.
Great. So the way this format is going to go is that I will ask some questions in a moderated format so that Alex can provide a detailed overview, not just of the insular cases, but of what impact they have today, what work the ACLU is doing in that regard, and what we as a society, as Phi Beta Kappa members, and as individuals can do to increase awareness of the role of these cases on the lives of those inhabitants of US territories. So first question, Alex, insular cases sounds like a very complex concept. What are the insular cases?
What are the insular cases? Insular means island related, or ever relating to an island, among other definitions. So the insular cases are a line of, depending on who's counting, it can be anywhere from 9 to 22 cases, Supreme Court cases spanning from 1901 to 1922, all having in common that they dealt with whether and to what extent constitutional provisions, US constitutional provisions, applied to the territories, the island territories that the US acquired after winning the Spanish-American War in 1898. So those territories include Guam, Puerto Rico, the Philippines, and Cuba, although they ceded Cuba and it became sovereign that same year. But Puerto Rico, Guam, and Philippines did not. And so those questions immediately sort of started presenting themselves to the court, to what extent merchants who wanted to conduct trade with those territories, or to what extent citizenship was automatically bestowed to people born in those territories, to what extent the Sixth Amendment, the right to a jury trial, extended to people being prosecuted in those territories. Those are some of the questions that these cases sought to answer. And unfortunately, the Supreme Court, this is the same court in 1901 that decided the infamous, much more famous Plessy v. Ferguson Supreme Court case just a few years earlier, that endorsed the now infamous doctrine of separate but equal, allowing for separate treatment on, in that case, it was railway cars where Black people were forced to go to the back of a a train car in New Orleans that was endorsed under the doctrine of separate but equal. That's how the Supreme Court then dealt with the meaning of the 14th Amendment's guarantee of equal protection. It's that same court that started to consider whether people born in the island territories had the same rights afforded to them as people in the mainland. And the Supreme Court, out of whole cloth, created a new doctrine that they made up called the Territorial Incorporation Doctrine, where they dictated that certain territories, such as Alaska, which had been acquired by the US in 1867, that was destined for statehood in the court's view, and therefore the Constitution did follow the flag there. That is, that people in Alaska had the full rights guaranteed to them in the US Constitution, and the constraints on federal government power applied in Alaska. However, for reasons that I'll elaborate on in a moment, that same doctrine was not expanded to cover the island territories. Rather, the ruling, which was entrenched in this, or the series of rulings in this Territorial Incorporation Doctrine, was that for all these other territories, these handful of territories, these island territories that the US just acquired, because the inhabitants of these territories are so many, there are millions of people in these territories, by contrast to Alaska, which much fewer in number. And in the court's eyes, they were savages, they were uncivilized, they were unfit to be bestowed with the full panoply of rights afforded under the US Constitution. This is explicit reasoning in these line of cases where the Supreme Court indulged in outright and explicit white supremacist ideology, where they endorse this view that we, the US, the court, interpreting the US Constitution, should withhold rights to the residents of these territories because they're unfit for to be sort of fully embraced by the US polity. So that Territorial Incorporation Doctrine, which ruled that the rights of the Constitution may or may not apply in the territories, it's up to each case as it comes before the court. That was a made-up doctrine, and it was a function of the same court that ruled that separate but equal was the law of the land. And that doctrine still exists today, where questions arise where whether particular provisions in the US Constitution apply to the residents of these territories, or the territories generally. And it leads the same doctrine, because it hasn't been overruled, leads to some disturbing results in lower courts rulings. And so, unlike Plessy v. Ferguson and the separate but equal doctrine, which was overruled famously, probably the most famous Supreme Court case in 1954, Brown v. Board of Education overruled Plessy v. Ferguson, in the same way that Korematsu v. US, which endorsed the mass internment of Japanese Americans, also on race-based grounds, that was overruled just a few years ago in Trump v. Hawaii. Unlike those two acknowledged racist cases, these line of insular cases and the doctrine, which is a race-based doctrine that underlies them, is alive and well today, and still informing not only Supreme Court cases, which are few and far between, but more importantly, lower courts, right? District courts who hear these challenges in the first instance. They look to these insular cases and they say, on any given question, whether a particular constitutional provision may or may not apply. And so that's what the insular cases are, and that's why, in some ways, they're still relevant today.
Great, thank you. It was a very, very informative introduction to the insular cases.